in the main merit list, they were in the waiting, and some of the selected candidates have resigned and did not join. Therefore, they made a representation that they should be taken into a main merit list and the appointment letter should be issued in their favor.
Yes.
My lord, that has been kept in abeyance, assigning a reason since the list is pending before the Honorable Court. Therefore, we cannot issue appointment letter to you. The matters have travelled up to the Supreme Court, and Supreme Court has affirmed the order which has been passed by the learned single judge, Your Lordship. Now, there is no list which is, my lord.
What was the order of the single judge?
My lord. I have annexed the order which has been passed by the Supreme Court.
See, the Supreme Court has affirmed the order of the single bench. Now, where is the order of the single bench, I am asking?
My lord, so far as the single bench order is concerned, that has not been annexed, my lord. I have annexed the order where the similarly situated person preferred a writ petition before this Honorable Court. Though they were on the merit list at waiting list number 3, I was at the waiting list number 1. And in that matter, Your Lordship, the direction has been issued to consider the case within a stipulated period, Your Lordship. Since, my lord, the matter has been adjudicated by the Honorable Supreme Court on 22nd August 2024. Thereafter, I made a representation. That representation is pending before the competent authority.
What? In a selection process of 2017, why this court in 2024?
My lord, the reason being, my lord, may kindly appreciate page number 17.
You could have filed a writ petition before this court saying that my candidature is not being considered as the other candidate.
My lord, we have intervened in that petition. My lord, our intervention application, they said you have other different recourse because they have said that the matter is subjudice.
Why should I permit you to
my lord, may kindly appreciate
2017?
page number 16 may kindly be seen.
Yes.
This is a communication, my lord, which has been made to me by the Department of Technical Education. My lord, may kindly come to
that
the last
was given
line.
to you in 2017.
My lord, thereafter, my lord, finally the list has been decided by the Supreme Court in the year 2024.
But you kept slept over your right for so many years.
My lord, until unless the list.
Vigilant about your right, you should have filed.
I was vigilant, my lord. I was vigilant.
You should have filed a writ petition, Mr.
My lord, I preferred a application before the I made a representation before the competent authority.
You should have asked. You should have come before this court and wait for the orders.
What is the reason that has been assigned by the state government?
Why should I decide?
My lord, this is not the case. I have slept for the long period, Your Lordship. My lord, kindly appreciate.
So, yes.
2017, I made a representation. They said we cannot decide your case until a list is being finally adjudicated by the Court of Law, Your Lordship.
What is the legal sanctity? What is the legal sanctity of that? You should have come to this court directing them. Whatever fate you should.
My lord, so far as the other similarly situated persons are concerned, they also preferred a writ petition before this Honorable Court in the year.
Why did you not come?
My lord,
why did you wait? You should have also come with the similar.
Since I was vigilant about my right. I was the only person who was vigilant about my right since the matter is subjudice before the single bench division when thereafter the matter is travelled to the Supreme Court. I was vigilant, Your Lordship. And what is the reason that has been kindly appreciate the reason that has been assigned while not taking a decision on my representation? They say the matter is subjudice.
2017. Yes.
My lord, may kindly come to the page number 21. P6 may kindly be seen. This is a petition preferred by a person who had the CL number 3 in a waiting list.
अब देखिए इस पे. However, we clarify that the impugned judgments would be applicable only to the parties who have approached the learned single bench of the High Court.
I am not asking any parity.
It is to state that the direction issued by the High Court would be complied with in a period of 3 months. That's all.
My lord,
that's all.
So far as this petition is concerned, Your Lordship, the person I am at the CL number 1. This person is at the CL number 3, Your Lordship.
He came to this court.
My lord, I also approached the competent authority, Your Lordship.
That is not the answer. My lord, when the Supreme Court says the impugned judgments would be applicable only to the parties who have approached the learned single bench of the court, then I will not touch the case.
No, so far I am not the petitioner in those petitions. I am not the person who has travelled up to the Supreme Court, Your Lordship. My case was that I was not the contract employee. So far as these petitions are concerned,
the order of the single bench?
Well, I will file it. Sure.
List after 2 weeks. Enabling the State Learned Council for the petitioner to place on record the judgment passed by the learned single bench. WPS number?
मैं फाइल कर देता हूँ सर.
Learned single involving the issue in respect to the issue involved in this petition. Yes.
My lords, may I point out just one fact, my lords? In the order passed by learned single judge, annexure P6, in that case, my lords, Firstly, it was filed in the year 2017, and secondly, there was an interim order in favor of that petitioner to keep one post vacant. That is why in para 7 specifically the court has observed.
But I will file a petition, Your Lordship. In that petition, I have also intervened.
So we'll look into it, yes.
My lord.
Yes. Obliged.